general family viewing.
Welcome. This is the third episode of Law Matters, a program that is educative, informative, and sometimes gives you instructions and guidelines on how to go about your Law Matters activities that concern you. It is a legal aid form of clinic coming to you via television, and we're coming straight live from Parklands at the Kenyatta University School of Law, based here in Nairobi. Send in your comments and questions that you may have regarding the topics of the day. We are on KUTV Kenya on Facebook. We are on KUTV Kenya Live on YouTube and on Twitter at KUTV Kenya _ Kenya. Today we are continuing with part 2 of family law, and I am joined by a guest expert who will tell us all about succession law. I am your host, Dr. Ngugi Kingara. Welcome, law expert of the day, friend of the show.
Thank you so
Kindly
much.
introduce yourself to our guests and the viewers at home, and then tell us what is your interest in family law.
Okay. My name is Angela Gitahi. I am a legal clinician. In fact, I'm an alumni of this university, graduated in 2018. And I work at McGill University in one of the projects that they run in Kirinyaga County.
Very good. I think in today's program, we are continuing where we left off. And I want to hear in your legal aid work whether you get many questions that have to do with succession.
Oh yeah, so many. I think this is one of the fields that we take a lot of time in the legal clinic tackling. Yeah.
Okay, how did you get started in your work in legal aid?
Here, actually, in this university. So this university, Kenyatta University School of Law, has a legal aid club. So that is why I started in 2016. I was in second year, and then I kept volunteering until I got fourth year, and I was a student coordinator. So that gave me the experience on how to run a legal aid clinic. After that, I went to Kenya School of Law. I was also in the legal aid club, and thankfully now this is what I think I'm doing for my career.
Oh, okay, that's quite a long journey you've come on.
Yeah.
And we are happy to have you because the continuation of the work you were doing there as a student is happening right now at legal aid on television through family matters, through law matters. It's like family matters, you know. We are talking family law, so I think that's why I'm getting ahead of myself. Okay. So tell our viewers, and what are the activities that one who is working in legal aid is involved in?
Well, a legal clinician, all you need first is a law degree, and what you'll be giving is information. So this is the vulnerable part of the legal of the law. So we deal with vulnerable persons who cannot afford advocates, prisoners, and so on and so forth. So in a day, what we do is just offer legal information. As it says, it's a legal clinic. So it's like a hospital. So a client will come and they'll tell you a story. My chicken, it jumped over the fence of my neighbor. So my role is to be able to fish out the legal aspects of it and advise them accordingly.
Okay, and now I understand that you have some partnerships that came on board, having learned the type of work you do. Can you tell us about that?
Well, I was hired by a professor from McGill University to be able to set up a legal aid clinic for his organization back in Kirinyaga County. Mm-hmm. And his idea was he wanted the students at McGill University in Canada to be able to offer legal aid services remotely through a tablet, computer, or a phone to the people back in the village. But I just asked one question: how will the students at McGill do it, since Canada, the Canadian law is different from the Kenyan law? So thankfully, being an alumni of this school, they allowed us to have a collaboration. So how it works is there are two students. So one student is in Kenyatta University, the other one is in McGill University. They pair up, and then they report to me. Now we talk with the tablet with me back in the village now with the client. So everything is remote.
So how is that working? I mean, people complain there's no electricity. Is that working well? Or how is are there any challenges in doing it like that, online, so to speak?
Well, I think the main problem is the network coverage, but that now goes beyond us. But we try and, mitigate on how to do it. Sometimes we look for hours where, the network at least is a bit better. Sometimes when it rains back in the village, the network is very, very bad. So we cannot climb on trees to look for network. Yeah. So that means then we'll just have to push the meeting to another day.
Oh, okay. Yeah. But I'm hoping that there aren't that many days that you manage to do your work.
No.
So now you can tell our viewer. So being a legal aid clinician is like one of the ways you can practice law.
Oh yeah. So I would actually encourage my juniors to take it up as a career. This is a career on its own. Your law degree is enough for you to be able to give legal information, but there are other areas of practice of law. Some of my friends are in corporate law, for example. Others are in academia, and others now, the ones who've been admitted to the bar, are doing like litigation and conveyancing.
Okay, yeah. Quite interesting. I think now they know you don't have to be admitted to the bar.
No.
Although, from my research, I know that you're just about to be admitted to the bar.
Yes.
How is that like? How are you feeling about that?
Relieved. Relieved. I think it's the end goal for every student once they come here. But of course, I have learned over the years that your law degree is enough. Although it's a plus, it's an advantage, that now I'll be able to stand in the High Court or the courts of Kenya and be able to litigate.
Okay. Yeah. So you are still within practicing even though before you admitted to the bar. And I know that some of the questions you get regarding the aid that you have to give in legal matters has to do with family law, because each one of us, like we've learned in our previous episode, comes from a family, and there are laws that mitigate the circumstances that happen there.
Yeah.
And therefore succession probably is one of those matters that come.
Yeah, one of the main ones actually. I think in the legal clinics across board, we will get issues of succession, property matters, and matters to do with like appeals for the people who are in prison, or how to get bail and bond, or in remand, people in prison or remand.
Okay, I think that's the cue for our viewers, that today we are tackling part 2 of family law.
Yes.
And the main topic of the day is succession law. So now, can you briefly tell us what is succession law all about, and the brief history of succession law in this country?
Okay, just as the name suggests, succession law is about succeeding, but in this case, we are not succeeding in life.
Yes.
We are succeeding the property of a deceased person.
Yes.
Sometimes we'll call it inheritance, sometimes we'll call it probate. So all those names to mean the same thing. And what we want to do is we want to respect the wishes of the deceased person on how his or her property is going to be divided amongst his heirs after his or her demise.
Okay, so maybe to inform the viewer, how differently structured is the succession law today of the nation Kenya from that one of our ancestors?
Well, we'll have to look at succession started way before even before colonization. Started in the pre-colonial period. If you would think about the Agikuyu community, for example, they had their own ways of succession, and not only inheritance of property, inheritance of stories, inheritance of of culture and all that. So this is something that is not very new. But with colonization, we happened to adopt the British legal system. But after independence, then in the 1970s, Parliament saw it fit to start working on a Law of Succession Act, which now came into play in 1981.
Okay.
Yeah.
Very interesting. I think, of course, they say culture is dynamic. From what we used to be and now colonization. That experience has brought us to where we are today.
Yeah.
And from my research, I learned that there are three key areas that have to do with the laws of succession.
Yes.
And one of those, the primary one, I think, is the claimants. Those people who are like supposed to be the direct beneficiaries of the property of the deceased.
Yeah.
And then, because of the approach to how those people get whatever the deceased left behind, there is a thing called Intestate
Intestate.
Intestate and
Testate.
testate succession. So, can you briefly define those for us, even before we start tackling them in segment 2 of this program?
Okay. So the succession goes through either 2 ways. It can go through the testate succession. This is where the deceased person has a will. I think we'll get into it later. And there's also the intestate succession. Simply said, the intestate succession, the deceased person died without having a will. So the only difference is there a will? Is there not a will? So that is testate and intestate succession.
Okay, and now claimants.
Yes.
Who are these in the eyes of the law? The first, top level, most considered beneficiaries. Who are these?
Well, it's the spouse. And because in the 21st century, it is not limited to the woman being the one to inherit. We also have, and the word spouse will stand for either a wife or a husband. So the spouse, in this case, would be the first one in line to inherit. And then the children. And then after the children, if there are no children, then they will go to the parents. And there's a whole hierarchy in the Law of Succession Act that defines the hierarchy. But this is intestate succession because this person has died without a will. Then the law provides for the hierarchy. Even if it is assumed that, the family, the immediate family is the one to inherit, intestate succession, then it becomes a bit different. Because if it's a will, the court will want to respect the wishes of the deceased person. So other people can be accommodated in the will as opposed to in intestate succession. Okay,
I think we'll tackle that one when we come to how wills are written and under what circumstances issues surrounding them are mitigated. But in terms of male spouses, we know that in history that males could probably not inherit from their wives. Is that true? So what does the law say about that?
Well,
the law of succession, that is.
Remember, we took this law from the ancestral area, the ancestral before colonization, that is, and at that time the Kenyan community was very, very patriarchal, and then we came to the 1981 Law of Succession Act, still very, very patriarchal. But things changed with the 2010 Constitution. And in the 2010 Constitution, it calls for equality between male and female. So, of course, the Constitution being the supreme law of the land and the will of the people, all other laws had to circumvent around the Constitution of Kenya. And one of the laws that was affected was the Law of Succession Act. That is to mean then male spouses and female spouses have equal measure and are seen equally in the eyes of the law according to the Succession Act.
That's good for us. Those of us who are male, we can inherit.
I think that's a good thing.
It's a good thing, equality, yeah? Now, for the standard to be met about who is a wife or who is a spouse, one has to be under the law to qualify as wife or a spouse, really. A
spouse. Yeah. So I think this is something that has been very contentious over the years, and the question has been who is a wife for the purpose of succession, but now I want to say who is a spouse for the purpose of succession. And a spouse is someone who has been married under the Marriage Act. Allow me to give a scenario.
Okay.
So Mr. Kamau marries Wangoi, and Mr. Kamau marries Wangoi in church, right? So that marriage is recognized under the Christian, it's a Christian marriage, so it's very monogamous.
Right.
However, Mr. Kamau, after a few years, decides, let me marry Wangeshi, but I will marry Wangeshi under, say, for example, the Kikuyu traditional system, which allows for polygamy. In that case, then, both of them will be wives for the purposes of succession. I remember my senior, Madam Leah, also, delved into the types of marriages and how they are accommodated in the Marriage Act. So following that, Wanjiro and Wangeshi will be wives for the purposes of succession. Then we will have, Njeri coming and sweeping in, and, they come in, during the preparation of the funeral.
Yes.
And they will say, in fact, me, I was a wife for the, I'm a wife of the deceased person.
Right.
But Njeri will not be recognized as a wife for the purposes of succession, also because she's not recognized as a wife in the marriage, according to the Marriage Act. Yeah.
Okay, so concubines, No.
No, slay queens, sugar babies, we call them all these names. No.
I'm sorry. Okay, now let's consider another thing. Members of the larger extended family, do they have a right to inherit the property of the deceased?
This is something I've seen a lot actually in practice, where a stepbrother will come and say, this is my brother, or you'll find a cousin of another cousin of the cousin who will now come and say, what, I also want to inherit in this property. Unfortunately, in a will, that could be if the deceased person had included these people in the will explicitly. But in intestate succession, and we are following not the hierarchy under the Law of Succession Act, that is going to be a bit very, very difficult, unless they prove that they were being taken care of by the deceased immediately prior to his death. That is to mean that if this cousin of the cousin of the other cousin of the cousin was, stayed with the deceased person for the first 3 years of his life and then left, and then now it's 47 years later, he can then not come and claim and say, in fact, he was taking care of me when I was a toddler. No. It has to be immediately prior to the deceased person's demise.
Okay, but in case the will now specifically cites this person should inherit, then the members of the extended family can come in through that loophole.
Yeah. In fact, even friends can come in through the loophole of, it's not really a loophole because these are the wishes of the deceased person. And what the court wants to do is it wants to protect the desires of the deceased person. Because have in mind the deceased person will not come back and say, no, I didn't mean this. This is what I meant.
Okay.
So we have to protect the respect and respect the wishes of the deceased person.
I see.
Okay.
So the second thematic area that we're going to talk about will be intestate, and I think you'll get the opportunity there to explain in detail what that is all about.
Yeah.
I think with that we have enough background knowledge on this, and we'll be right back. Keep watching. We are on social media platforms. Send in your questions, and we'll be right back.
Cancer is the second leading cause of death in the world. However, chances of survival have increased due to the improvements on screening and treatment. In fact, Cancer Awareness Day is celebrated every year on the 4th of February, seeking to create global awareness.
Cancer, if diagnosed early, is curable. It's important that when you discover an abnormal swelling or a change in skin color or your normal body contour, that you seek medical attention early so that if it's cancerous, it's detected early and actually treated.
This week on Focus on Health, we are going to be demystifying matters cancer.
Reducing time wastage enhances productivity.
E-workers' main backbone is to enhance productivity, right? So we want to make sure that students' productivity is enhanced in the sense that you can quickly jump on a scooter, shorten that 20 minutes to, let's say, 5 minutes, get into your lecture on time, and you're not sweaty, and you're still fresh. With regards to how we're going to deploy, we're going to have a number of designated parking zones all over the campus.
As a team, there's that money we set aside for buying our own skates, quality ones. That's the quality one is the ones that we give to people who know how to skate. There's different types of skates. There's K2, there's Saber, there's speed boot, and there's freestyle, that's Saber.
Welcome back. Welcome back to our second segment. We are continuing with law matters here. And we are talking succession. Remember, Kenyatta University has a mandate of community service. We also are very big on research, and part of what you're seeing here comes out of that. And through the Legal Aid Clinic, we've been able to bring this educational television show to you, where we host expert guests such as my learned friend of the day, Ms. Angela. Welcome back.
Thank you.
Intestate law. It keeps slipping out of my tongue. Mm-hmm. Okay, let's redefine that, or rather define that once again before we start tackling it for the viewer to hear.
Okay, so testate law or testate succession,
yes,
it can be a tongue twister. So yes, testate succession is where the person or the deceased person dies when they have written a will. Just simply that.
Okay, and in it we're hearing a key element there, yeah, the will. Mm-hmm. So under what circumstances are the wills drawn? And actually, let's start properly. Mm-hmm. How many types of wills are there?
Well, there are 3 types of wills. There's a written will, there's an oral will, and there are privileged wills.
Okay.
Yeah.
Oral wills.
Yes.
Let's start with that.
Well, oral wills, as the word says, they're oral. So the deceased person will be speaking out his or her last wishes on how he or she wants his or her property to be divided. Yes. Allow me to use his property to be divided, right?
Okay.
But the thing and what the court will be looking at, because all these will have to go through the court for them to, to approve and all that, to just make sure everything is okay.
Correct.
What the court will be looking at in an oral will is it that it has been made in front of witnesses, like 1 or 2 witnesses, and these witnesses must be competent. So the test for competence is the person must be an adult and the person must be of sound mind. Right?
Okay.
Another thing that the court will look at is the duration of the oral will prior to the death of the deceased person. So the threshold is 3 months prior to the death of the deceased person. Another story. So Mr. Otieno, for example,
yes.
Mr. Otieno is in hospital and he has been told that he has 1 month to live, right? Mm-hmm. And so he calls his people, he calls 2 witnesses who are competent and, shares his last desires, right?
Right.
And when that happens, remember it's 1 month, yeah? So now Mr. Otieno, fortunately in this case, does not pass on at that time. Okay. So he stays like maybe 1 or 2 years later, and then that is when he crosses over to the other side.
Okay.
And what happens then? Is that will valid? Unfortunately, it's not, because the threshold is 3 months. And the reasoning behind it is so that, we want to respect the wishes. And this oral will has been made in contemplation of death.
The deceased.
Yeah.
The person who didn't die, but eventually dies.
Oh, yeah. And then now, if the person dies over like 1 or 2 years after maybe the oral will has been made, now this will has not, he did not die at the time we expected him, to pass on. So this time now, after 1 or 2 years, it will not be in contemplation of his death unless he made an oral will after, or now in the 3 months bracket.
So 3 months is a very important period. So is it assumed that this person, if the person didn't die, could change his or her mind between that, after that time? Yeah,
that is the reasoning behind it. Things could change, Was he, at this time, maybe he was not in the state of mind that, he would be 1 and 2 years later. Maybe there are things he wanted to change, so we cannot hold on to the very first one. And if at all he still wants to maintain on the first one, then he can always make another oral will within the 3 months bracket prior to his death.
Okay, now the question of witnesses, because of issues of credibility.
Yeah.
The witnesses, you've said sound mind, but is that all?
An adult of sound mind, but I would advise my viewers to look at things like impartiality. For example, you do not want to have a beneficiary being the one, who is a witness. because, even if we look at it from a logical point, and the very worst comes out when it comes to inheritance matters, especially among families. What happens is like they might alter, and now we are not really sure if like this will, it was the will of the deceased person. So just to ensure that, I would encourage our viewers to get like an impartial person, a very impartial advocate, not your family friend advocate who knows a lot of things, a very impartial advocate. Or after the will is written, then in case of a written will, then they can always bank it with like a trusted bank. Of course, all banks are trusted, but with a bank which now is the letter or the will is kept now with other valuables in a safe.
Some banks are trusted.
Oh, some banks. Okay.
Well, that's just my personal opinion. Now, I think that's very useful for the viewer to know, especially cases. I think one that I like that you mentioned is that, for example, brothers and sisters, you take the two and then you put them in the room and you say your oral will. Then the third one might say, he didn't say that, he loved me best.
Yeah, and we see actually a lot of problems coming up, where a parent is like, you will take this car, you will take this house, you will take this land, and then, the deceased person, goes, and that's it for them. And then now the children now are left fighting, saying, but daddy said this, but mommy said that. Yeah.
Okay. So now, before we tackle the question on validity of the will, let's talk about the written will and the circumstances under which that one is written and what one has to do to safeguard that.
So the written will, as it said now, as opposed to the oral one, this one is written. So it will be written. We want to give freedom to the person to write just the way they would like. Of course, to name the beneficiaries and also to divide the property now. It's going to be divided. And what people call it, they call it will estate planning. And they're advocates who are specialized in doing will estate planning. So they'll sit and divide the property and then safeguard the will. The same threshold applies. So here you'll need 1 or 2 competent witnesses, right? And the test now for competency applies as with the oral wills.
So instances where a will can be invalidated, I think I could hear you implying through the example you've given there, biased witnesses.
Yeah.
Probably that's one of them. But tell us, within the standard of succession law,
well, wills
under
are
what circumstances?
Thank you. Wills are revoked every other day, and this is because there is just a very, very slight, suspicion that this will was not written as the desire of the deceased person. Remember, the deceased person cannot come back and say, no,
Yes.
I wanted this to go to that. So, in as much as we want to respect that, the will may be revoked because one of, as you had said, impartiality, or maybe it has been altered in a way, or in some circumstances, like the people who are expected to benefit and who we establish is like the spouse and the children have not been catered for in the will. Usually, and this is mostly what happens, they will apply for revocation of the will and they will say, probably, my dad or mom was coerced into making the will. Or if it looks like there are unclear circumstances, like maybe this person lived with the wife and the children in harmony, and then all of a sudden the whole will reads that they have left the property to like the gatekeeper or, the sugar babies or the slay queens. That looks a bit
odd.
Or if this person probably was in ICU, and in ICU is when now the will was written, the court then now will question, the lucidity of the person, of the deceased person prior to his death. Was this will written when he was okay? Was he in that emotional or unstable state of mind to be able to write this will?
So in a case like that, the person feels, I am really the rightful beneficiary.
Yeah.
What recourse do they have? How do they go about claiming what they think is rightfully theirs, and what sometimes the law actually suggests is rightfully theirs?
Well, once the probate process begins, there's a time limit that's going to be given, to anyone who has any complaint, and this applies both to testate and intestate succession, right? And I'll give an example. So let's take Juma. Juma has a let me use a daughter this time.
Okay.
Juma has a daughter called Mary, for example.
Yes.
And Juma and Mary are not in good terms. In fact, Juma and Mary have not been in contact for the last, 30 years or 50 prior to the demise of Juma. So Juma did not want to, or does not want to include Mary in the will. And he explicitly says, I do not include Mary in the will because of A, B, C, D. At that time, of course, Mary will contest, right? So Mary, okay, so the court will look at, and what are the circumstances, or what was Mr. Juma's desire that he does not want Mary to inherit? Yeah. So once the court looks at that, if it was a valid reason that, on Mr. Juma has explicitly written, I do not want Mary to inherit, then the court cannot, or the laws cannot then interfere with the wishes of the deceased person. But there's an exception. If Mary, for example, is not in the will, but she was taken care of by, she was given pocket money, or her school fees was being paid by the deceased person immediately prior to his death, and the fact that now she is a child, then now it changes a little bit, and now the court will look at it in a different way and actually question the validity of this will.
Okay, I think we'll tackle more on that in the latter segments of this part. What about gifts in contemplation of death? What qualifies as gifts, and what are the circumstances of which one gets to inherit does one inherit the gift, or just get the gift and rightfully is within their own right now to receive them?
Yeah. Say Mr. Patrick wants to give Anne a gift, for example, in contemplation of his death. Yes. That is very, very much allowed, but there is also a threshold. So the threshold is this gift must be movable. Movable to say that you cannot gift land in contemplation of death. So it could be something like a car or a TV, something that, can be moved about. Another thing that the court or that we look at in a gift in contemplation of death is if this person then does not die at that time, will the property is the property able to revert back to
the gift that is?
Yeah. Can this car be returned now to Mr. Patrick, for example? Another thing that the court will look at is the court will look at if I'm sorry.
You forgot that. Anyway, I think if it comes back to you, we'll be able to pick it and confirm what was in your thought. But now, I think what we've been talking about a lot is when a will has been written and someone has actually done that. But there's now the intestate succession.
Okay.
And to remind our viewers again, intestate succession.
Intestate succession is where the deceased person dies without having written a will.
Yes.
Yeah.
And this is, I'm sure from your experience, probably with cases that you have come across, is where there's a lot of controversy and contention.
Yes, actually intestate succession is the main thing because Africans believe that once they write a will, then they're inviting, death into their homestead. Yes. So they will keep off writing wills.
Yes.
And I think also in the African culture, you're not supposed. It's a taboo to contemplate your own death. So a lot of gifts, we don't see much of that. We also don't see much of wills, but we see a lot of intestate succession, which is now governed by the law of succession in detail. Yeah.
Okay. Yeah. So you don't want to. It's almost as saying, if I dig my grave in the backyard, then I'm like, I want her to die.
Yeah.
But what is your advice, though? Because before we leave it, what is your advice to the viewer on writing?
On writing a will? Well, especially if you would like to include, your friends or your sugar baby. Now, this is where they're included in the will. But now when it comes to intestate succession, it's a bit different because now the court will seek to protect the blood relation or those people who are taken care of by the deceased immediately prior to his or her death.
And actually, that's a very good point to now ask you the question. So who are the rightful claimants of this deceased property who dies intestate?
Okay, so the rightful claimants, one is the spouse, and as we had said, because it's the 21st century, it's either the man or the woman.
Yes.
So one is a spouse, and then it goes to the children, biological, what we call quote-unquote illegitimate children, or children born out of wedlock, or adopted children, or children taken care of by the deceased immediately prior
Yes.
to his death. So there is and then if there are no children, then it goes now to the parents of the deceased person.
Yes.
And then from the parents of the deceased person, now we'll be looking at siblings, and then it goes on. Now we'll be looking at, we'll be looking for relatives, right? If there are no other relatives like cousins and all that, then the property goes back now to public trustee. And that means that all that you have worked for, if it is not then now inherited by someone, then it goes back to the government. You know what that means? Like it's like paying taxes in your grave. So
when you die.
And there's so many unclaimed assets. Even the other day in the news, like there's so many of these properties which are not inherited, or people are not interested, and now they revert to the government.
Wow.
Yeah.
I don't think I want that. Now, so what is the process of acquiring this property if I'm the rightful beneficiary in the person who dies intestate?
Okay, so we can use an example of Mr. John. So Mr. John has unfortunately passed on, and now you have the certificate of death with you, and now you want to start the process of succession. So the very first thing that you'll do is you'll get the letter from the chief. And the reasoning behind this, which I think again is a bit backward, because now, with the movement and all that,
Yes.
The chief is said now to have known you. So the chief will write a letter, address it to the court, and this is how they will say it. They will say, I am the chief of this village. I know the deceased person. The deceased person hailed from my village, and this family is known to me. These are the beneficiaries, and these are the properties. And then they will request the court to help now the beneficiaries wind up on the succession. So that's the first thing. You need a letter from the chief. The second thing you'll need is a consent. So what you need and how you'll be approaching the court, you'll be asking the court to give you like a grant to administer that property. So you need consent from all the beneficiaries, and this is where they choose an administrator. It could be one, or it could be one or two persons, depending. But when it comes to minors, there are minors in like minor beneficiaries, and minor in this age I mean children.
Yes.
Persons under the age of 18. Then now it changes a little bit, and we must have more than, or two or more. We must have two or more administrators.
Okay,
right?
So two or more, okay.
Yeah, and then the third thing that you'll need to sign an affidavit showing that you're not bankrupt. So you'll need to like declare your finances, because the last thing you'll want is to have like a bankrupt person being the one who will be the administrator to that property. I mean, we can see where that will go.
Yes, he might make sure that this, some of this property probably comes there.
Yeah, he's not bankrupt anymore.
Okay.
Yeah.
So now this question of the chief, because really that one is a real issue.
Yeah.
It's a real issue in the fact that if I'm living in an urban center today, and this actually is a fact, it's very far away from where I was born and raised, really.
Yeah.
So how is the law dealing with that when these hearings are being heard, or when you've presented your client in court and the document is saying that, but the person really lives elsewhere?
It's quite unfortunate. Like, for example, if I hail from Nyeri and I move now to Nairobi, and then now my chief in Nyeri now has no clue about my whereabouts, and then here I am, say, okay, as a beneficiary saying, oh, this is who and who and who and who, and they might not be able to tell you. So what has happened is the now chiefs are soliciting funds from people, from these beneficiaries, and a lot of succession cases are not starting because the chief will simply refuse to write a letter for you, and then you'll keep following up with the DO, the DC, and it will just, this is the one thing that I've noticed, especially in the village, like they you keep going round and round in circles looking for that letter, but someone has simply refused because one, you've refused to pay, or two, they simply do not know you.
Okay, so if any one of the documents listed here now, of that the ones that you've presented, is missing, where does one go?
If is it like
let's say, particularly that letter of the chief, as we speak today?
I think that should be an area of reform because again, so many succession matters have not started because like a family is being, like the chief wants like 5,000 or 10,000 to be able to write this letter. So now the family gives up and does not start the process. So now what happens? This property eventually will go back to now the public trustee.
Wow.
Yeah.
Very interesting.
Yeah.
I think this is a discussion that must go on, and I know it's going on our social media platforms. Keep sending us your contribution, and we'll be able to comment and also respond to your questions when we come back.
Yeah.
Continue watching us. We are live on KUTV Live, Kenya. We're also on Facebook at KUTV Kenya, and on Twitter at KUTV_Kenya. We'll be right back with responses to your questions. Stay tuned.
On the next Straight Talk Africa, we'll take a look at informal housing and unplanned communities. Is there a place for them in big urban centers? We'll look at what the mayor of Freetown, Sierra Leone is doing, how she's bringing changes to her city, including its unplanned communities. We'll also talk to a Nigerian American who's making a big difference in affordable housing in Washington, D.C. Join me, Heidi Adams, on the next Straight Talk Africa.
Lola is an app that gives you a chance to watch videos, listen to audios, and read articles wherever you are for free. Motivational stories, dramas, campus life, technology, lifestyle, adventure, sports, academics, jobs, entertainment, and more. Download Lola now on Play Store. All you need, you got Lola.
This couple met in diaspora. They fell in love and had a child. They decided to move back home and make things official. Now, here is the bombshell. They found out that they were related. Wow. With Orbital Global, you can save yourself the embarrassment.
How well do you know your family lineage? Your cousins, uncles, aunties, nephews, nieces? Orbital is here for you. Visit www.orbitalglobal.com. Orbital Global, connecting families, uniting nations.
Welcome back to the third and final segment of our show. We are talking succession law. We've just heard about interstate laws relating to interstate. A person who dies without a will.
Yeah.
And I'm still joined by my learned friend, Angela Gitai. And very interesting, and I'm predicting that there'll be questions relating to this important topic.
Yeah.
I think I've just seen one from Brian Balawi saying that, can you sue your father for your property? I don't know whether he means when your father died, you sue the estate or something like that.
No, the whole point of succession is to inherit property after the death of someone. So I think in the context that we talk about like being the prodigal son, where you demand for your inheritance before time.
Yes.
No, the law does not allow that.
Okay. And I'm seeing another question here from Wakale Entertainment. Interesting viewers. Kindly, on succession, what happens when someone with properties dies and that person is not known to the family? Not well documented on the will, but the family has clues of the properties.
Oh, okay. Sometimes when a will is written, or the person, sometimes when the will is written, they might leave out something, like maybe he wrote the will or in 2018 and acquired new property in 2019. The person passed on in 2020. The family does not know of this in 2019, and the deceased person did not alter the will to include this property. So what will happen is this bit of property that was not included in the will still go through succession, but to go through intestate succession.
Okay.
Right? So now we will have the court considering like the blood relatives.
Okay.
Yeah.
I see, and maybe this one relates to that. From Eliud Edwin. He's saying, and another question is, because I want to read them just the way they wrote it so that they get to hear themselves and their phrasing on TV.
Okay.
So he says, assuming a parent who has not disclosed all properties he or she owns to the children, upon death, what happens to such property which the children aren't aware of?
Oh, well, again, if it is a will and something that they will not still know whether the property exists even after the demise, and then they won't do anything about it. That property then will be said to be unclaimed and will go back now to the public trustee. But then in a case where they find out, there's a piece of property, and I would actually encourage, the parents to tell someone, tell even your best friend, tell your best couple about these properties, because then your children end up suffering looking for, all these properties. And if they find the property, or like, there was a property in like Kamulu, for example,
yes,
then the process of succession is never finished. So now we will go back and divide this property again. So they'll still apply and say, we had left this property, let us now go through the whole succession process again and then divide the property. So it becomes a bit longer. Yeah.
In my opinion, I'm thinking it's also in the best interest of the viewer to find out about his or her parents and probably what they own. Would you say?
African parents will not, but we're encouraging especially African parents to disclose this. You don't have to disclose it to your child, because they'll say, if I tell my children, they will not work hard. So this is my property, they will look for theirs, I will not tell them.
Yes.
But then you see after your demise, now the children are left helter-skelter in and out of court.
Yes.
So it would be advisable to just disclose, even if not to them, you can disclose to an advocate or a family friend, tricky, or someone that you trust, someone who's impartial, sound, and an adult, of course.
I like that part where you relate that even if you don't give it and you die and they don't know, the state gets to take it and you still pay taxes while you're dead.
Imagine. So
it is in the best interest for us to inform maybe our children.
Yeah.
I think we'll take a question from the studio audience right now. I see one question there in the back.
Opportunity.
Let's hear you, please.
Thank you very much for the opportunity.
Thank you.
And my name is Magero Peggy Ashley, and this is the question I'd like to pose. Does the law of succession cater for children born out of wedlock? Thank you.
Okay, you had that one.
Yeah. Remember, I had said illegitimate children in court. First of all, thank you, Ashley, for that question. It's brilliant. So children born out of wedlock are children for the purposes of succession. And that is to mean, and let me give back an example. So there's a husband and a wife, and they have children, right? Unfortunately, the husband and the wife pass on, right? and then they're left with children. And then now Njeri from somewhere just comes and says, you know what, in fact, even me, I am a wife, and in fact, I even have kids with this deceased person. So what happens then? The court will take these children if there is proof that they were being taken care of, one, if they are biological children, and now they look at things like, you know, DNA. They will look at things like, the court will look at things like the DNA. They'll look at the birth certificate, for example. Those children will be considered children for the purposes of succession and should inherit from their father or their mother. But this sugar baby Njeri, right? This sugar baby and the slay queen will not inherit, but her children will. Yeah.
And I think the thing to underline here is that people should know, I guess, there are no illegitimate children in terms of this law, isn't it?
Yes.
Okay, then we'll take another question from the studio audience over there, gentleman in red.
Yes, thank you so much. My name is Baraza Joseph. I really want to know what happens in a polygamous marriage. Like, do all spouses get equal share of the property? Yeah.
Okay.
That's a very, very interesting question. Thank you for that, Baraza. Well, before the 2010 Constitution, I think there was a gray area in that section, like who should inherit in the polygamous family, and how it was before was, say there are 5 houses, right? In that polygamous family, there's a first house, a first wife, kids, and so on and so forth. So before, in each individual, the property was divided according to the houses, right? So if it was 10 acres of land, each house would get 2 acres, 2 acres, 2 acres. But then that's not fair, because probably the first house has 10 children, the second house has 2 children, the third house has 1. Yes. So the one with 1 child gets more property than the one in the first house. So what did the law come and do? And I think the law wants to be very, very fair. So now it changed so that now the property is divided equally amongst the spouses and the children. Equally. It doesn't matter, like 1 acre goes to the first house, it has to be equal across board. It's fair, isn't it?
Okay.
Yeah.
Very good. Balancing, I think. Scale.
Balance.
Okay. One last question before we wind up. A gentleman in black over there.
Okay, so thank you once again. So my name is Fadili, and I'll be asking my question in terms of now altering the provisions of the will. Now, earlier we talked of a person being able to alter his provisions in the will, maybe now through a codicil. But then I'll be talking now through maybe now in the court of law now. What are some of these instances? Because I remember earlier you asked if some of these things can be altered by a court of law, and you answered in the affirmative. So I would want you to just shed some light on some of these circumstances where the court can alter these provisions of a will. Thank you.
Okay. Thank you. That's a very good question, Fatili. Thank you so much. So the court will interfere. Remember, first of all, the court wants to protect the wishes of the deceased person. So that the court will be very, very slow to interfere with the wishes of the deceased, but eventually it will. For example, if a son or a child has not been included in the will and it looks a bit suspicious, like why was this person not included, or the sugar baby in this case was included and the whole family was not included, and it looks very suspicious, the court will now step in, because the law will take precedence over your testamentary, or the freedom that you have to write a will. And all these things must be looked at, like equality and all that in the Constitution. And also like legality. So you cannot then indicate like I've stolen property in the will, and like that now say, oh, okay, it's stolen, oh, sorry, now let's proceed and just like divide it because there's nothing we can do. So in such circumstances now the court will interfere and see and and look at each section individually and revoke those that do not augur well with the law.
Okay.
Yeah.
Now, I know we are coming to the end of the show, and I think we could have taken more questions, but I do know that because of your legal aid work, you wanted to have a parting shot.
Yeah.
So, go ahead.
Okay. This is my advice to all adults or all adults who have property, and we will all go. That's for sure. It's a sad reality, but we will all go. And I would especially talk to the parents and tell them, and this is one thing, this is actually the major thing that comes to our desk across board. I think the whole of Kenya, I think Africa, that parents will tell you, you know what, my daughter Mary, this one is yours, this property, this one is yours, and then they will come and tell John, you know, not they're in good terms with John, not they're not in good terms with Mary. John, now this is your property.
Yes.
And then now a few months later, now Mary and John are not in good terms with their parents. They tell Peter, you know what, Peter, this is now your property. So after you're gone now to a better place, and all these children now are left saying, Daddy said this, Mommy said this. It's really, really not fair. If you would like to, and I would encourage for wills to be written, and if not that, it is also good to know that if you choose not to write a will, then there is a hierarchy, and all children will inherit equally. So it's not very good to tell your children, you know what, we'll inherit something bigger, because once you're gone and this has to go through the court process, the court will say, no, this is not the way it goes, this is the way it should be. And now the kids are left fighting, and the matter stays in court for years and years and years and years on end. And you'll understand these children, because they want to hold, you know, something that your parents have given you in their death. You'll want to hold that clearly. So it causes a lot of problems. Please write wills. If not, also please disclose your property, and also don't promise too much, because now the law will come and say it doesn't work like that, and your children will be left fighting forever.
You heard it. Write the wills. Make sure that you manage your matters and leave them in order when you go on. It has been a very pleasant experience this evening. Thank you very much. This has been our third episode. Tune in next week when we'll be talking about children's law. Thank you very much, Angela, for accepting our invitation and for educating us. We would like to thank our studio audience for being vibrant and being responsive to our show. The crew that made this show happen, thank you so much. Keep the conversation going on our social media platforms, and we'll see you next week, same time, same place. I've been your host, Dr. Ngugi Kinyara. Goodbye.
Kenya